What you doing, you little muppet? What are you doing, you? Have you seen what she just done to her, mate? Yeah. What's he doing here with Bot? What's he doing with Bot?
Yo, push boy! Push boy! Push boy! Yo, push boy! Push boy! Push boy! Push boy!
Who's been arrested?
You push boy!
Who?
Fucking set up muppets, every one of you. That voice does not do no wrong.
What are you doing?
This is between me and you. You've got a suit on your muppet.
I've got Jonathan for nothing.
Damn it. Damn it. Damn it. Damn it. Dickhead.
Get on!
Oh! Oh! Who giving me? Who giving me? Get up! Give it! Ah, you just got it! Ah! Oh, yeah. Don't move. Citizen. Get up here! Get up here! Get up here! Give it me! Give it me, Jay! Give it me! Give it me, you stupid blonde bitch, mate! You little smuppet! All this for one thing, mate, on estate! Hey! Big J on a madam, boys! All this and everything! For one person! For one person, mate! Sausages! For one person, you sausage! For one person! For one person, mate! Get up! Get up! Hey, yeah, meet man. Oh, big clown, big clown, big clown. Big clown. I've never seen estate like this in a long time.
What you've just seen is footage of an incident that took place recently in Lawful near Leeds, West Yorkshire. The police officer you saw in the early part of that clip there spraying people is the subject of criticism online and possible disciplinary proceedings, depending on the outcome of a professional standards inquiry at West Yorkshire Police. She's spraying them with something called PAVA spray, and it's the very same police officer who was a centre of controversy in another incident involving the police in Leeds, and I made a video about that incident which you'll find on my channel. That video was called "Have Cameras Replaced Personal Responsibility?" I could have titled this video "The Sequel" because the same point really comes out of this again, which is how people think that disrespect can be justified by a camera. Nobody in their commentary on this latest incident mentions the disrespect of the crowd towards the police officers, which seems to me a glaring omission from news commentary. Similarly, in the previous incident, nobody mentioned that the teenager had been found drunk and had been escorted home by police officers, or the irresponsible attitude of the mother, who posted this on her TikTok account about the latest incident. Turning back to the incident in Lawful, the question I want to ask is whether what the officer is doing there is legal. Let's start by looking at PAVA spray and what it actually is and the legalities of its usage. PAVA stands for pelargonic acid vanillamide, also known as nonivamide. Basically, in everyday language, nonivamide is a hot acid derived from capsaicin, which is a chemical irritant found naturally in chili plants. It's the sort of thing that food manufacturers may use to make spicy chicken and stuff like that. This is why the broader, more general name for it that you sometimes hear, especially in the United States, is pepper spray, though within policing people, often the distinction between what they call OC pepper sprays on the one hand and PAVA spray on the other is made. Police chemical irritant sprays, including PAVA, have to meet a technical standard set by the government's Defence Science and Technology Laboratory. The PAVA sprays most British police forces use are called Capta 2 and Capta 360, which are products supplied by a company called Civil Defence Supply Limited. Some forces use a different product called PAVA TW1000. The spray consists of a 0.3% nonivamide solution in monopropylene glycol, water and ethanol. This is sufficient to temporally disorient an individual sufficiently to bring him under police control, while avoiding prolonged discomfort to the individual. It's not true to say that PAVA spray is non-lethal. It's more accurate to say that it is less lethal, and that is the technical phrase used within policing. There have been cases of people dying after being sprayed with PAVA, but it's not clear that PAVA was a cause of death in those cases. An example is the case of Alan Hay, who was sprayed by an officer of Police Scotland while being arrested and died in custody the next day. PAVA spray is meant to be used as a last resort, and typical situations where it may be used include where an officer needs to stop somebody resisting or from carrying out an attack, or to stop somebody reaching for an offensive weapon. In the past, British police officers in these situations relied on batons or sometimes used CS gas. CS gas is rarely in use now. PAVA spray is more potent than CS gas, it's more painful to the subject, but it's not flammable, and there is also a much reduced risk of contamination of other people nearby, which are the main reasons it's preferred over both CS gas and traditional OC pepper sprays. The problem with CS gas in particular is that, being inflammable, it's risky to use alongside firearms and tasers. Some points of relevance to make about PAVA spray are that it has a large spray pattern with a maximum effective range of around 4 metres, but its maximum accuracy is between a 1.25 metre and 2 metre range. The distances vary between the canister and the subject rather than between the user and the subject. The way PAVA spray works on someone is that it causes the eyes to close and the subject experiences severe pain. Recovery from the effects of the spray happens between around 15 and 20 minutes. Note here that to work effectively, PAVA spray must enter the eyes. Turning to the relevant law, subsection 5(1)(b) of the Firearms Act 1968 prohibits PAVA spray as a weapon of whatever description designed or adapted for the discharge of any noxious liquid, gas or other thing, meaning that it is unlawful for a member of the public to possess it. However, under subsection 5(4), police officers, prison officers and other servants of the Crown have lawful authority of the Secretary of State to possess and use PAVA spray, subject to certain conditions. Those persons, when authorised, are therefore exempt from prosecution under section 5, provided they meet the conditions set down. Subsection 5(5) states that it is an offence to fail to comply with any of the conditions of the lawful authority. As far as I can tell from the published material available, subsection 5(5) is now practically defunct. There are no extant conditions as such. I think this is due to sections 53 and 53A of the Police Act 1996, which empower the Secretary of State to make regulations regarding the use of less lethal weapons and equipment, and also empower the Secretary of State to require that police forces put in place their own codes of practice in this regard. The main code of practice pursuant to section 53A is the College of Policing Code of Practice on Armed Policing and Police Use of Less Lethal Weapons. This code of practice is mainly to do with the scientific, technical and policy aspects, including development and approval of the spray and delivery mechanism, distribution and storage, public consultation on use, and training of officers authorised to use the spray. So this code, which has statutory effect, provides the legal framework in which UK police forces use the spray and other weapons and firearms, so that they should have access to a variety of weapons and ammunition that allows for a variety of tactical options through a differentiated use of force and firearms. The basic idea is that the availability of less lethal options, such as PAVA spray, can enable officers to resolve the situation prior to it becoming necessary to discharge a firearm in order to save life. What still underpins everything about policing in Britain, really, is that police officers are citizens in uniform. The significance of this being that while police officers do have special powers, those powers are limited. They must act under the rule of law, and their right to use force is no different to the right of you or I to use force. In other words, while police officers enjoy a greater scope within which they can use force, including being required to do so by their superiors, the basic principle that makes their use of force legal is the same as it would be for you and I. Even when an officer is armed, such as here with PAVA spray, the underlying principles in law are still the same. The officer doesn't have some special dispensation to run up the street spraying an acidic solvent in people's faces. The same applies to firearms. That means, just like you and me, a police officer is permitted to use only such force as is necessary, proportionate and reasonable in all the circumstances. When police officers are required to use force to achieve a lawful objective, such as making a lawful arrest, acting in self-defence or protecting others, the legal bases are to be found in the following. Section 117 of the Police and Criminal Evidence Act 1984, which states that reasonable force may be used by an officer, if necessary, to exercise a power conferred on a constable, for example when making an arrest. The Human Rights Act 1998, which in summary provides that force must always be proportionate, legal, that officers are accountable, and it must have been necessary. Section 3 of the Criminal Law Act 1967, which states that any person, not just the police, may use reasonable force in the circumstances to prevent crime or to arrest offenders and suspected offenders. And common law, under which any person, again not just the police, may use such force as is reasonable in the circumstances to protect themselves or another, defend property, prevent crime or carry out a lawful arrest. Reasonable, proportionate and necessary is typically interpreted to mean such force as the officer reasonably believed was necessary. This means the officer can be wrong and can use excessive force, but it can still be legal if the court is satisfied that the officer had formed a reasonable belief that the force used was necessary. This is, if you like, a subjective-objective test. We start with what the officer believed. We then ask whether the officer can have honestly formed this belief or whether, in all the circumstances, the officer's belief was reasonable by the standards of ordinary people, i.e. the jury. It can be one or the other. Note the nuance here. This is not quite the same as asking whether the officer's actions were reasonable. Although the two things are similar and closely related, they almost sound the same, and I imagine even the courts sometimes confuse the two. It is possible for a court to decide that the officer's actions were not reasonable, were even excessive, but nevertheless the officer acted within the law because he reasonably formed his belief in the circumstances presented to him. That distinction is going to be very important here. It sounds complicated, but it's actually just a way of explaining something that's commonsensical. It's a way of saying that when it comes to the criminal law, we can't just assess on the basis of a rigid standard because that would bring injustice. We have to take account of a person's mindset. It's really the difference between, on the one hand, looking at something entirely objectively and deciding that the officer's actions don't meet a given standard, and on the other hand, allowing for the subjective point of view and accepting that while the officer's actions may not meet a given standard, the officer did act in a way that he considered reasonable in the circumstances. This reflects two different ways of looking at a situation. One is disciplinary, the other is rooted in criminal law. The disciplinary proceedings may hold the officer to a fairly rigid objective standard, and he may be disciplined irrespective of the outcome of criminal proceedings. The criminal law has to look at it differently and take into account what was in the officer's own mind. Obviously we can't see into his mind, but we can draw out inferences from what the officer himself says and what we can see happened, and we make an evaluation of it using our own everyday experience and common sense. The next thing we need to cover is that the police themselves have put in place policy, practice and guidance on the use of irritant sprays. This is both at the national level and also on the part of local forces. For obvious reasons, local policies, practice and guidance seem fairly consistent with the national equivalent. The structure of this policy, practice and guidance is as follows. The foundation of it has been articulated in the United Nations Basic Principles on the use of force and firearms by law enforcement officials. According to the UN Basic Principles, law enforcement officers in carrying out their duty shall, as far as possible, apply non-violent means before resorting to the use of force and firearms. At the national level, you have the Code of Practice I mentioned earlier, which is the College of Policing Code of Practice on armed policing and police use of less lethal weapons. That Code of Practice informs the College of Policing Code of Ethics, which we'll discuss. This in turn informs the College of Policing Authorised Professional Practice, which is a suite of documents known as APPs that set out agreed best practice in pretty much every area of operational policing. Then you have local policies on the use of force and the use of irritant sprays. All of this policy and guidance can be distilled down to the following points. First and most important, a point that runs through all the guidance and policy I've seen, is that when police officers use PAVA spray or threaten to use it, they are using force. This may seem like a statement of the obvious, and it is a statement of the obvious, but it is very important because it's at the centre of everything that the police tell their officers about the use of PAVA spray. Chief officers of local forces must establish policies and guidance on the use of PAVA spray and must ensure that officers authorised to use the spray have attended approved training courses. PAVA spray is just one tactical option for officers that sits alongside other options. It is a decision for the individual officer whether the spray should be deployed in a particular situation. The use of PAVA spray may be appropriate against those offering a level of violence which cannot be appropriately dealt with by other levels of force and/or against violent offenders, other than those armed with firearms or similar remote injury weapons, where failure to induce immediate incapacitation would increase risk to all present. Police officers who intend to use PAVA spray shall identify themselves as such and shall give a clear warning of their intention to use irritant spray, unless to do so would compromise the safety of any person, or warning would be clearly inappropriate or pointless in the circumstances of the incident. The wording for such a warning should be something like, "If you do not comply with my instructions, I will use irritant spray." The spray should not be used at a distance of less than 1 metre unless the nature of the risk to the officer is such that this cannot be avoided. The spray should not be used in an enclosed area, for example in a car, on a subject who is restrained or handcuffed, as a crowd dispersal tactic due to the possibility of other officers and innocent bystanders being affected, unless the nature of the risk to the officer is such that these things cannot be avoided. In all such cases, officers must be prepared to justify not only their use of the spray, but also their decision to use it in these circumstances. After spraying, officers should offer verbal reassurance to the subject as to the temporary effects of incapacitant spray and advise them to breathe normally. The subject should be exposed to fresh, cool air as soon as possible and encouraged to open his eyes as soon as possible to encourage tears to form and wash away the solvent. The recovery period will vary from individual to individual, but if symptoms persist after 15 to 20 minutes, copious amounts of tap water should be administered to the eyes by either the subject himself or a forensic doctor or other medical personnel. The subject should be closely monitored throughout the recovery period. This is of utmost importance. Generally speaking, individuals who have been sprayed do not require medical attention. One of the most important passages in the documents I found during my research is from a document no longer in use, the ACPO's 2009 guidance on the use of incapacitant sprays, but I think this passage is still relevant because it states well the position. Let me read it. The nature of policing is so diverse that it will never be possible to document guidance to cover every encounter or eventuality. What is important is that any action taken is lawful. Action must be proportionate to the competing rights of individuals, and any force used should be no more than absolutely necessary in the circumstances. In this regard, individual officers must be prepared to account for their decisions, to show that they were justified in doing what they did and that they acted reasonably within the scope of the law on the use of force. Similarly, chief officers will need to be in a position to justify any decision or action in order to avoid or defend civil claims. So what do the policies, guidance and practice documents say, if anything, about how individual officers should make these decisions? For a while, a concept known as the hierarchical continuum of force was quite fashionable in police circles, in which an escalation of force was considered the right way to approach these situations. That thinking is no longer in vogue within the police because I think it came to be recognised as unrealistic. Instead, what's expected of officers is that less lethal options such as PAVA spray are selected, having considered the capability, limitations and proportionality of the option in the prevailing circumstances. Many factors will impact on that decision, some of them we've just covered, and therefore it is not considered practical to predetermine the most appropriate options as part of a continuum of force, namely to consider each option in strict hierarchy in terms of an escalation of force, if you like, or to use each in turn on that basis until whatever is the tactical objective has been achieved. The police nowadays refer to something they call the National Decision Model, which used to be called the Conflict Management Model, and is an example of an authorised professional practice I mentioned earlier, or APP. The National Decision Model requires officers, especially supervisors, to consider the following points when making decisions in a situation of disorder, such as the one we saw in the footage. The person's behaviour and their level of resistance. If the person is not compliant, the impact factors which apply to both parties. The appropriate level of response in accordance with the reasonable officer response options and in conjunction with the National Decision Model. The term used there, impact factors, relates to the officer's assessment of a situation and his own ability to deal with the incident and the threat posed. Impact factors that may influence such an assessment include relative strength of the people involved, skill level, exhaustion, alcohol or drugs, imminent danger, mental derangement and own perception of willingness to resist. These factors aren't mandatory to consider and there isn't an exhaustive list. The reasonable officer response options, in other words the action or non-action that the officer should take, include the following tactical options. Officer presence, for which the considerations include method of approach, whether to wear uniform or plain clothes. Tactical communications, which can be verbal or non-verbal, with or without batons. Primary control skills, which can be the use of empty hand skills, i.e. something not involving a weapon or implement, and involves considering the escort position when someone is in custody, arm and wrist locks, compliance techniques, use of handcuffs or use of baton for restraint techniques. Secondary control techniques, which includes the use of irritant spray, such as PAVA, if and when available, or a taser. Defensive tactics, which includes blocks, strikes and takedowns, empty hands and batons, followed by control techniques. Deadly force, which is any action that may cause serious bodily injury. The decision about these tactical options will be influenced by the following factors: the immediacy of any threat, the limits of information to hand, the amount of time available, the available resources and support, the officer's own knowledge, experience and skills, the impact of potential action on the situation and the public, what action to take if things do not happen as anticipated. The National Decision Model also asks that officers reflect on their actions after an incident and ask these questions of themselves. Were my decisions and actions proportionate, legitimate, necessary and ethical? Were my decisions and actions reasonable in the circumstances facing me at the time? Were decisions communicated effectively? Were decisions and the rationale for them recorded as appropriate? Were decisions monitored and reassessed where necessary? What lessons can be learnt from the outcomes and how the decisions were made? West Yorkshire Police have their own use of force policy, which has clearly been written with the National Decision Model in mind and regurgitates many of the points I've just mentioned. The policy states, in relation to use of force, the National Decision Model should be adopted when being able to justify the decision made when considering use of force. It can be adopted for situations where use of force may have been considered but not needed. allowing for the reassessment where required. All this sounds complicated, but the idea is that police officers trained to use the National Decision Model make almost instant decisions following its principles, and it provides the ability to rationalise decisions. The National Decision Model is the basis of most police training on the use of force. Another APP I want to make mention of is the College of Policing APP on armed policing, in particular the section on the use of force, firearms and less lethal weapons. This contains a list of factors or questions that can be used to assist in establishing whether a use of force is reasonable. Is the use of force lawful? Namely, is the aim one of those outlined in Section 3 of the Criminal Law Act 1967, Section 117 of the Police and Criminal Evidence Act, or common law? Is the degree of force proportionate in the circumstances? Were other options considered? If so, what were they and why were those options discounted? Was the method of applying force in accordance with police procedures and training? Also of relevance to use of force decisions is a report by Her Majesty's Inspector of Constabulary, as it was then called, on the 2011 riots in England. The report was entitled Rules of Engagement and was a review of police actions during the riots. The report came up with 10 key principles on use of force by the police. These included the following. Principle 2. Police officers may, consistent with their duty, use force in the exercise of particular statutory powers for the prevention of crime or in effecting a lawful arrest. They may also do so in self-defence or the defence of others, to stop or prevent an imminent breach of a peace, and to protect property. Principle 3. Police officers shall, as far as possible, apply non-violent methods before resorting to any use of force. They should use force only when other methods have proved ineffective, or when it is honestly and reasonably judged that there is no realistic prospect of achieving the lawful objective identified without force. Principle 4. When force is used, it shall be exercised with restraint. It shall be the minimum honestly and reasonably judged to be necessary to attain the lawful objective. Principle 6. Any decision relating to the use of force which may affect children or other vulnerable persons must take into account the implications of such status, including, in particular, the potentially greater impact of force on them. Principle 8. Individual officers are accountable and responsible for any use of force, and must be able to justify their actions in law. The report also formulated a 3-part test for the use of force by police officers, as follows. First, would the use of force have a lawful objective, for example the prevention of injury to others or damage to property or the effecting of a lawful arrest? And if so, how immediate and grave is the threat posed? Second step, are there any means short of the use of force capable of attaining the lawful objective identified? Third step, having regard to the nature and gravity of the threat and the potential for adverse consequences to arise from the use of force, including the risk of escalation and the exposure of others to harm, what is the minimum level of force required to attain the objective identified, and would the use of that level of force be proportionate or excessive? Another important document for police training purposes is the College of Policing Conflict Management Guidelines, which can be summed up in just 3 words: de-escalation, communication and negotiation. The aim is to reduce the need for physical force by emphasising in police training certain non-physical skills and attributes such as verbal and non-verbal communication, situational awareness, emotional awareness and self-regulation, and active listening. Verbal communication skills include learning various different models and heuristics for how to handle difficult and troublesome people and people who verbally or physically resist the police. I'll give you one example from the Conflict Management Guidelines which is relevant to public order, and is called the 5-step appeal, which is a verbal escalation an officer can use in the event of resistance and involves giving the person every chance to comply with requests. The first step is a simple appeal, which is to ask the person to comply with your request. The second step is a reasoned appeal, which is to explain why the request has been made, what law, if any, has been broken, and what caused the request. The third step is a personal appeal, which is to remind the person that they may be jeopardising things that are high priorities to them, For example, loss of free time if arrested, loss of money, loss of income, possibility of a criminal record, loss of respect of their partner and family. The next step is final appeal, which is to tell the person what is required and use a phrase that means the same as the following. If there is there anything I can reasonably do to make you cooperate with us? The final step is action, which is the use of reasonable force, which may be the only option left in the case of continued resistance. The point of all this is to bring it back to the subject of a video, is that since we all agree that the use of PAVA spray is the use of force, an individual police officer has to make his decisions in light of all the training he has received about managing conflict. And the officer should have in mind the national decision model and may make reference to the conflict management guidelines for this purpose. West Yorkshire Police do have their own policy on PAVA irritant spray, and I've taken a look at it. Most of the points have already been covered, but of those that have not been, the salient ones are as follows. PAVA spray is primarily designed for dealing with violent people who cannot be otherwise restrained. Any use of PAVA irritant spray must be reasonable and justified using the national decision model, and only be used against individuals offering a level of violence which cannot be appropriately dealt with by other tactical options, and violent offenders where failure to induce immediate incapacitation would increase the risk to any and all persons present. PAVA is issued for defensive or offensive use, but must not be regarded as a replacement for other routinely distributed protective equipment. PAVA is appropriate to use in crowds or in confined spaces due to the lack of cross-contamination issues. Officers must ensure where possible and prior to use that a warning is shouted before spraying in short bursts and repeating if necessary, not continually spraying, aiming directly at the individual's face. Officers must remember to not use PAVA at less than 1 metre to the subject unless the use of force is proportionate and necessary to the circumstances. Officers should speak to any individual sprayed to reassure and advise them that any effects from the spray are only temporary, and to encourage them to open their eyes and focus on breathing normally. Although these policies do not have force of law in themselves, they represent what is expected of officers who use and possess PAVA spray canisters, and so are relevant to an evaluation of whether an officer's actions in a given situation were legal according to Section 5 of the Firearms Act 1968 and other law. I should also make mention of the College of Policing Code of Ethics, which applies on a statutory basis to all police officers in the territorial police forces of England and Wales as a code of practice, and the College of Policing claims that the code should apply to all who work in policing, regardless. I will refer in particular to Principle 2 in the Code's Standards of Professional Behaviour, which demands the qualities of authority, respect and courtesy from police officers, and says this: I will act with self-control and tolerance, treating members of the public and colleagues with respect and courtesy. I will use my powers and authority lawfully and proportionately, and will respect the rights of all individuals. Examples given in the Code for behaviour that meets this standard include remaining composed and respectful, even in the face of provocation, retaining proportionate self-restraint in volatile situations, stepping forward and taking control when required by the circumstances, keeping an open mind and not prejudging situations or individuals, using my authority only in ways that are proportionate, lawful, accountable, necessary and ethical. And also Principle 4 is of interest, which is about the use of force, and states, I will only use force as part of my role and responsibilities, and only to the extent that it is necessary, proportionate and reasonable in all the circumstances. What the standard goes on to explain is that the officer must use only the minimum amount of force necessary to achieve the required result, and the officer will have to account for any use of force. In other words, justify it based upon an honestly held belief at the time that the force was used. I do think that a passage I mentioned a few moments ago, paragraph 1.1.5 of the Association of Chief Police Officers 2009 guidance on the use of incapacitant sprays brings everything we've just discussed together and summarises with cogency what the legal obligation on the police and individual officers is. It's worth reading again. The nature of policing is so diverse that it will never be possible to document guidance to cover every encounter or eventuality. What is important is that any action taken is lawful. Action must be proportionate to the competing rights of individuals, and any force used should be no more than absolutely necessary in the circumstances. In this regard, individual officers must be prepared to account for their decisions, to show that they were justified in doing what they did and that they acted reasonably within the scope of the law on the use of force. Similarly, chief officers will need to be in a position to justify any decision or action in order to avoid or defend civil claims. Now we've looked at all that, let's refresh our memories and watch the whole footage of the incident through again. Then we'll go through it a further time with me pausing it and giving commentary.
What you doing, you little muppet? What are you doing, you? Yeah, have you seen what she just done to her, mate? Yeah. What's she doing here with Bot? What's she doing with Bot? You know, push boy! Push boy! Push boy! Yo! Push boy! Push boy! Push boy! Push! Who's been arrested? You push boy! Who?
Fucking set up muppets, every one of you. That boy's just not done no wrong.
What are you doing? This was between me and you. You've got a suit on, you muppet.
I'll start this analysis with some background to the incident. As explained in a statement released by West Yorkshire Police, a car was stopped on suspicion of a traffic offence. A crowd gathered round as officers were dealing with the driver. For some reason, a violent melee and altercation developed. Eventually, 2 men were arrested on suspicion of offences including assaulting police officers, possession of controlled drugs, and possession of a knife and offensive weapon. A quantity of suspected Class A and B drugs, a knife and an offensive weapon were recovered. The 2 men arrested have been released on bail. Given that they were arrested, the matter is sub judice, so I will not make comment about them specifically. The question arises, was the use of PAVA spray, as seen in the footage, legal? I'd like to show you a demonstration video about PAVA made by Lincolnshire Police. This is an officer showing us how PAVA spray should be used.
Hiya, I'm Tom. I'm one of the operational trainers here at Lincolnshire Police. I'm responsible for officer safety training alongside numerous other things. Today, what I want to talk to you about is about PAVA. PAVA is an irritant spray, the police have got available to them as a tactical option. What PAVA is, it stands for pelagonic acid vanillamide. Don't worry, you don't need to know that. As I said, it's an irritant, and when it comes into contact with the subject, especially into the eyes, the best way I can describe it is it's like wet fire. So that's what PAVA is. This is a synthetic made pepper spray. However, it has replaced the old pepper spray. So unlike the old CS gas, where everyone got the good news, it would potentially fill a building, this comes out in a jet, so you can target a specific subject.
Notice what he says there, it's very important. You target a specific subject. It's not just something that you spray indiscriminately while wearing protective gear yourself, which is more characteristic of how CS gas will be used. You're meant to use it to spray a specific individual in each burst in order to ensure that the usage is lawful.
When it comes to using it on the subjects, again, it's a tactical option for the police to use. For whatever reason, they may not use a baton, they may not be able to get hands-on because of the threat level. So for instance, if a subject were to have a bat in their hand, I strongly wouldn't advise any other police officer or any police officer to go and try and get hands-on if someone's acting aggressively with a bat in their hand. Good thing about PAVA is you can use it from a distance. It can be up to 15 feet. So again, it saves you having to get hands-on and it protects officers from any injuries what would arise in getting hit with a bat. As you can imagine, it wouldn't be very good.
I've got an issue here with what he's saying, which goes back to what I found in the various policies and guidelines that the police issue themselves, and I think it's a good point. If you spray the PAVA on somebody who is armed, whether with a bat or a firearm or whatever, isn't there a risk that the person will then lash out, and given that they've been temporarily blinded, doesn't that increase the risk of somebody getting hurt? Because of course the subject is still armed potentially.
So I'm just going to quickly example how to use PAVA and how it can be good and how it can be effective. An officer would draw the PAVA, he would take aim, adopt a good, strong, stable firing stance, and the target area we're looking for is around the eyes. I'm going to fire it in short, sharp bursts, starting at the centre of mass, working the way up to, again, like I mentioned, the target area, which is the eyes.
Notice the posture he adopts there. It's a deliberative posture. He's using both hands to hold the weapon. It's not the posture of somebody just indiscriminately firing bursts of PAVA at anybody who happens to be around. It's a posture of somebody who is deliberately and carefully directing the spray at a specific target.
Spray!
He shouted a warning.
Hopefully that would have the desired effect. The potential bat could have got put down. The subject's going to be concentrating in obviously protecting their eyes because they're going to suffer extreme amounts of discomfort. It can be described as wet fire, so the effects it has when it comes into contact with the eyes is wet fire, so imagine that how you can. And now it's safe for the officer to approach because the distraction's been taken away from the bat in hand to the hands going up potentially to protect the face.
Let's now go back to the incident footage. This time I'll be pausing it and adding my own thoughts and observations. The first thing we see is that there's some kind of melee going on. She runs in, but so do two other officers. The disturbance is really in two parts, and if I play it back in slow motion, you can see clearly what happens. Two men are arrested and there is some attempt from people in the crowd to obstruct and discourage the police from this course of action. Additionally, the men being arrested are resisting. The police bring the men behind that red car on the right while other officers deal with the crowd on the left there. And you can see that the lady officer joins to deal with the crowd in order to get them away from the scene of arrest, and you can see significantly that she gets into an altercation with one or two in the crowd. Meanwhile, going back to the scene on the right, the two men are being arrested and restrained on the ground behind that red car, and they are still resisting arrest. Again, just to say for emphasis, on the right, behind the red car, the police are struggling with the men they are trying to arrest. And on the left, you can see the lady officer there is still in an altercation, and on the other two officers who rushed in with her, they have come to her aid, and she's now readying with the PAVA spray. At this point, you can see what the police have tactically achieved. On the right, they're still struggling with the arrests, but there's now a line of police officers to discourage any further encroachment on that scene. On the left, three officers, including the lady officer of most concern to us, are among the crowd to keep them away from the efforts to make the arrests. It's obvious to me that the police approached this with a plan. For one thing, not all officers are authorised to carry PAVA spray, and it must have been foreseen that she will be in a situation of confrontation and may need it. But it's obvious that the officers' movements at the scene are choreographed, consciously or otherwise. It's a simple plan, which is to guard the scene of arrest and push the crowd away, but you can see that the officers are applying their training, probably without even having to discuss it amongst themselves. They just apply it unthinkingly. However, the crowd are still there on the left of the screen. There is still disorder. The general legal position is that in normal situations, the police in this country cannot give orders, so the basis of telling people to move away is three things. First, simply the idea of the officers having personal space just like any other person. Second, the broader tactical objective of ensuring that the arrests can take place in a way that is safe and efficient for the officers. And third, to restore the King's peace, which is a fundamental and ancient duty of police officers and also ordinary citizens. Against that background, the lady officer starts with a PAVA spray. You can see that the man she's about to fire on seems to have his arms by his sides and doesn't look to be a dangerous threat. Let's watch on. She sprays him and it's hard to judge the distance there. It may have been less than a metre, but hard to say. If I play back that slowly, you can see the stance she adopts there. Compare it with the stance of the officer from Lincolnshire Police in the demonstration video. He uses both hands and adopted a very deliberate stance, whereas she's using one hand and her aim seems to be not so much to actually impact the subject target as deter him and make him move back. Again, I can only reiterate, the way she sprays people there seems to be not so much as a means to incapacitate a threatening person as to discourage a person from remaining at the scene. It's effectively a crowd dispersal technique, if you like. She's clearly shouting warnings now. She didn't when she first started using the spray. That last one looked to me to be less than a metre from her, but it's hard to say for sure, to be fair.
What you doing, you little muppet?
At this point, she stops using the PAVA spray for a moment and rejoins the tactical line of officers around the arrest site. The situation now is that they've cleared the immediate area around the arrest of almost all of the crowd, except maybe one or two individuals. That means the PAVA has clearly had its desired effect. One concern I have there is that it appears she sprayed a youngster who we can then see walking away with her hands over her eyes in the next clip.
What are you doing, you? Have you seen what she just done to her?
That's the young girl I'm referring to. It appears to me that she wasn't a threat to the officers or anyone else.
What's he doing here with butt? What's he doing with butt?
The police have achieved what they needed to, which is to clear the immediate area around the arrest, which you can see taking place behind the line of officers. Despite all the commotion, we can say that the police are in control of the situation.
Who's been arrested? You're pass by. Who?
Fucking set up muppets, every one of you. That voice does not do no wrong.
What are you doing? Difference between me and you, you've got a suit on, you muppet.
I'll stop it there. I want to draw your attention to paragraph 1.3.1 of the Code of Practice on Armed Policing I was referring to earlier. The paragraph says, "The British model of policing by consent is based on the principle that the power of the police comes from the common consent of the public, as opposed to the power of the state. The police service in England and Wales has long been generally unarmed. The use of firearms by the police should always be a last resort, considered only where there is a serious risk to public or police safety. For policing policy purposes, a PAVA spray canister is a firearm, to use the word as a term of art, and as we discussed earlier, there's a whole section in that code of practice on irritant sprays. Was there a serious risk to public or police safety, to quote the code, in this incident? The incident that we've just seen, I think that has to be considered questionable. That in itself doesn't address our question about the legality of using PAVA spray here though, because a police officer has discretion and can act in the heat of a moment to deal with a pressing situation. How we should assess this officer's actions is through the national decision model, because that is a standard that the police apply internally, and it is a structure given to the training of police officers for public order situations. In each case, prior to deploying the PAVA spray, the officer needed to consider the target person's behaviour and their level of resistance. None of the people we saw who were sprayed were offering any resistance, so the only reason for spraying would be if the officer considered that the individuals were a threat either to that officer or to other officers. I genuinely can't see how any of those individuals could have been considered a threat. None of them were armed. Most of them were nowhere near the immediate site of the arrests taking place behind the red car and showed no intention to advance on the site of the arrests or interfere in the arrests. Does this mean that the lady officer's actions were not legal? If we relied on guidance in documents such as the College of Policing APP on armed policing and its chapter on use of force, firearms and less lethal weapons, and the College of Policing's Code of Practice on armed policing and police use of less lethal weapons, and Rules of Engagement, the review of the 2011 riots, and the College of Policing Code of Ethics, we would see a heavy emphasis on the need for self-restraint on the part of officers and keeping the use of force to a minimum. We could therefore quickly come to the tentative conclusion that her actions may well not have been legal, but I'm not sure it's that simple. Just to remind you of something that I mentioned earlier, West Yorkshire Police's own use of force policy contains this paragraph. In relation to use of force, the national decision model should be adopted when being able to justify the decision made when considering use of force. It can be adopted for situations where use of force may have been considered but not needed, allowing for the reassessment where required. The national decision model asks that we consider impact factors based on the officer's assessment of a situation, the officer's own ability to deal with the incident and the threat posed. There was no threat from the individuals sprayed. However, we do know that 2 men were arrested during the incident, and we also know that the police found at the scene a knife, offensive weapons, and Class A and Class B drugs. In that context, we could accept that the officer perceived a threat and applied a general judgment that the scene needed to be cleared of the crowd, and that the crowd could generally present a threat, and it was therefore necessary to deploy a level of force so as to discourage the crowd from interfering in the arrests and to further ensure the safety of officers. Against that background, the national decision model asks us to consider what are known as reasonable officer response options, in other words, the action or non-action that the officer should take. These include various tactical options which you can see here. But it's important to understand that these are not a continuum of force, and although these options can be used as a basis for the escalation of force in a dynamic situation, there is no insistence on this. An officer could instead jump immediately to any one of these. I think we can rule out officer presence. We saw from the footage that this in itself was not enough. It's clear from the footage that the police officers applied their training to divide the crowd from the scene of arrest, and the tactical objective of the police was successful. For me, when applying the national decision model, the question we have to ask is it likely the tactical objective would have been achieved without the need to resort to the secondary control technique, i.e., in this case, a PAVA spray? Could the officers have relied on the non-invasive crowd control skills and tactics that we also saw them use in the footage, including blocks and a display of batons? I have to say, I think the answer is uncertain, but I think we can come to some tentative conclusions as follows. The officer's actions in using the PAVA spray assisted the tactical objective. If the officer had not used the PAVA spray, it would have been a messier situation in which the police had less control. For this reason, the officer, I believe, does have a good argument that to adopt a more progressive escalation based on a continuum of force, such as a 5-step appeal contained in the conflict management guidelines that I referred to earlier, would not have been nearly as effective as her decision to simply deploy the PAVA spray. Again, referring back to the national decision model, the officer had limited time within which to make her decision. It was a snap judgment she had to make. She did have other officers around her, but her aims were to protect those officers and enable them to complete an arrest and restore the King's peace, which is fundamentally her job, and she did achieve those aims. I would question whether she applied her knowledge and skills correctly in the way she used the PAVA spray, because she was using it with one hand in a posture that suggested she was not targeting the subjects, but instead trying to encourage them to clear the area. That kind of indiscriminate usage, or less discriminate usage, could result in an innocent bystander being sprayed. Indeed, I believe that did happen. A young lady was sprayed who it seemed to me was not involved with the crowd and just happened to be standing nearby. On the other hand, there's no legal restriction as such on the tactical scope of usage, and we go back to the point that the manner in which the officer used the spray achieved its aim and contributed to achieving the tactical objective. The National Decision Model also asks officers to reflect on their actions after an incident and ask these questions of themselves. Were my decisions and actions proportionate, legitimate, necessary and ethical? Were my decisions and actions reasonable in the circumstances facing me at the time? Were decisions communicated effectively? Were decisions and the rationale for them recorded as appropriate? Were decisions monitored and reassessed where necessary? What lessons can be learned from the outcomes and how the decisions were made? Some of those questions we can't answer, but the first two questions are of concern to us, so let's attempt to deal with them. Effectively, these are two questions in one and go back to the central question of this video, which is, were the officer's actions legal? It seems to me that her actions were not inconsistent with the National Decision Model, but she did stray quite radically from some of the policy and guidance that applies to the use of PAVA spray, including the PAVA Irritant spray policy of her employer, West Yorkshire Police. Specifically, it appears some of the targets may have been sprayed at less than a metre. That's only permitted if justified by the situation. PAVA spray is not supposed to be used as a crowd dispersal tactic due to the risk of innocent people being caught. She was spraying people indiscriminately without regard to the threat they posed. She didn't target the eyes in every case, and at least one of the individuals sprayed was entirely innocent, and that may have been a child. She should have issued a verbal warning prior to spraying on each occasion, but did not do that on the first few occasions. It appears there was no reassurance and aftercare for individuals who were sprayed, though this is not just her responsibility, to be fair. Let's say that it's decided by West Yorkshire Police Professional Standards Department, or the IOPC, that the officer's actions may not have been legal and they decide to pass a file to the Crown Prosecution Service for further consideration. I believe it is possible that could happen due to what happened in this part of the footage. There we see her spray an innocent bystander who may have been a child, and she did this at a point when the situation had been brought under control. She overstepped the mark. The offence is likely to be either assault by battery, contrary to Section 39 of the Criminal Justice Act 1988, or assault occasioning actual bodily harm, known as ABH for short, which is contrary to Section 47 of the Offences Against a Person Act 1861. I think a charge of ABH would be more likely, and that's what I'll focus on here, but an assault by battery charge would involve similar considerations to those I will outline. The defence here would be that the force used was lawful on some or all of the following bases: prevention of crime pursuant to Section 3 of the Criminal Law Act 1967 and common law, including the need to make a lawful arrest; exercise of police power under Section 117 of the Police and Criminal Evidence Act to effect a warrantless arrest pursuant to powers under Part 111, Sections 24 to 33 of the Police and Criminal Evidence Act 1984, or Section 26(2) and Schedule 2 of the same Act, and or self-defence or defence of another pursuant to common law, and or defence of property pursuant to Section 3 of the Criminal Law Act 1967. In response, a prosecution would have to adduce sufficient evidence to satisfy a jury beyond reasonable doubt that the officer was either not acting in defence of herself or another, or not acting to prevent a crime or to apprehend an offender, or not acting in accordance with any other power under the Police and Criminal Evidence Act, or if she was so acting, the force used was excessive. The line of argument would obviously depend on the defence put forward. The offence of ABH is committed when a person intentionally or recklessly assaults another. thereby causing actual bodily harm. It must be proved that the assault by battery occasioned or caused the bodily harm. Bodily harm has its ordinary meaning and includes any hurt calculated to interfere with the health or comfort of a victim. Such hurt need not be permanent, but must be more than transient and trifling. It can include something that results in no apparent injury but is merely painful. The big point in the prosecution's favour here, and something that if I were a prosecutor I would be talking up and emphasising to the jury, is a distinction between necessity and reasonableness. What a prosecution in a case like this would be saying, in essence, is that the use of force was not justified in the circumstances, indeed was excessive. The defence will be saying that the force used was lawful on the ground of Section 3 of the Criminal Law Act 1967, and possibly also the common law defence of self-defence. The two are related because the common law approach involves the interpretation of Section 3. Section 3 allows the officer to use reasonable force to prevent crime and assist in a lawful arrest, and as such, the officer's use of force was necessary to help bring the situation under control. But the prosecution would reply that necessity does not always equate with reasonableness, and the nature and degree of force used needed in that situation. My overall conclusion, I stress this is based only on the footage and I don't know all the facts of the incident, is as follows. First, in regard to criminal law, my overall view is that the officer's actions in using the PAVA spray were within the law, in that her actions were necessary and proportionate in the circumstances she faced, according to her own reasonable belief. It may well be that her own reasonable belief was wrong and she acted excessively, but I think it was possible for her to form a reasonable belief that it was necessary and proportionate to use the PAVA spray in those circumstances, and I would expect a jury to give her the benefit of a doubt, and I think that is right. She's acting in the course of her duties, and she's making a split-second judgment based on the situation she finds herself in, which involves suspicion of possession of firearms, a knife, and Class A and B drugs, and a group of people, some of them yobs, who it appears are trying to interfere in one or more arrests of suspects. The fact that individuals may be unarmed doesn't matter. Unarmed individuals can still commit assault and can still impede police in their duties. I think the problem a prosecution of the officer for ABH or battery on that young girl would face is the need to prove criminal intent. The courts have indicated that in cases such as this, whether the accused has a criminal mindset has to be addressed on the basis of the facts as the accused honestly believe them to be. To that extent, it is a subjective test. There is, however, an objective element to the test. The jury must then go on to ask themselves whether, on the basis of the facts as the accused believe them to be, a reasonable person would regard the force used as reasonable or excessive. Section 76 of the Criminal Justice and Immigration Act 2008 provides further clarification on the operation of the existing common law and statutory defences, and states that whether or not the use of force was reasonable in the circumstances will be decided with reference to the circumstances as the officer believed them to be at the time of the use of force. Subsection 76(3) confirms that the question whether the degree of force used by the defendant was reasonable in the circumstances is to be decided by reference to the circumstances as the defendant believed them to be. Subsection 76(4) provides that where the defendant claims to have a particular belief as regards the existence of any circumstances, the reasonableness or otherwise of that belief is relevant to the question whether the defendant genuinely held it. However, if it is established that the defendant did genuinely hold the belief, he may rely on that belief to establish the force used was reasonable, whether or not it was a mistaken belief, and if it was mistaken, whether or not the mistake was a reasonable one to have made. In other words, the crucial test at this stage is whether the belief was an honest one, not whether it was a reasonable one. However, the more unreasonable the belief, the less likely it is that the court will accept it was honestly held. However, subsection 76(6) states that if the force used was disproportionate, then it cannot be considered reasonable. What all this means is that in a criminal trial, the prosecution would need to show that the officer intentionally implied force in the knowledge it was not reasonable to strike the girl with the spray, or, in the assessment of a jury, was reckless as to the reasonableness of applying force. Though if the officer genuinely believed that her actions were reasonable, then they are reasonable as long as the force used was not disproportionate. Here we probably will be looking at a prosecution based on the mindset of recklessness. I think judged in context, taking into account the analysis I've given you of how the officer was at all times working towards a normal tactical objective, and taking particular account of section 76(3) of the 2008 Act, I think it would be hard for the prosecution to prove recklessness. Recklessness has to be more than a mistake. To explain further, intent or recklessness could be more easily shown if it was a situation that had gone on for a bit longer, and in which the officer could see that order and peace had been re-established, and nevertheless she persisted in pursuing people and threatening them with the spray. That would be a common assault if it was a mere threat, or ABH if a spray was then discharged, based on either a malicious intent on the part of the officer or simple recklessness. I think in spraying the innocent girl, the officer was negligent rather than criminal, because it was clearly a mistake and she was acting under an honest belief in there being an offence in progress and/or a threat to the completion of a lawful arrest. It does appear the girl who was sprayed was just a bystander, and while sometimes the police may have to use force against bystanders, this was not a situation in which it was needed. The prosecution may point to subsection 76(6) and argue that the force used could not be reasonable as it was disproportionate, because the officer could have reverted back to another, less invasive, tactical option, such as simply telling those individuals to clear the immediate vicinity, and if they didn't, she could have tried forceful persuasion without resorting to the spray. But subsection 76(7) sets out two further considerations that should be taken into account when deciding whether the force used was reasonable. Both are adopted from existing case law. They are that a person acting for a legitimate purpose may not be able to weigh to a nicety the exact measure of any necessary action. That evidence of a person's having only done what the person honestly and instinctively thought was necessary for a legitimate purpose constitutes strong evidence that only reasonable action was taken by that person for that purpose. Now, that particular test I think was really intended for householder defence cases, but nevertheless it does formally apply to all cases of defence of the use of force, so we can use it here. The tactic of using the spray did work very effectively, and while reasonableness and proportionality are separate considerations to necessity, they are integrally linked to necessity. A different tactic could have been used, but there was no way of knowing for sure that it would have worked. I don't believe the officer was reckless, as that would require that she just abandoned all thought and discrimination and engaged in an unjustified risk. She did act indiscriminately in using the spray, but there was a tactical objective behind it, and once it was clear to her that the tactical objective had been achieved, she stopped. Turning to discipline, I'll start with some important case law. The 1996 case of Regina and the Chief Constable of Thames Valley Police ex parte PCA decided that a CPS decision not to prefer a criminal charge did not automatically mean that an officer is excluded from disciplinary proceedings based on the same facts. The point is that even though I believe a successful criminal prosecution is unlikely, that won't rescue this officer from disciplinary proceedings. And I think that is probably going to be the thing that gets her, because although, as I've demonstrated, her actions were not inconsistent with the national decision model, she departed quite radically in a number of significant respects from police policy and guidance on the use of PAVA spray, and she did spray an innocent person, which I think was negligence rather than criminal. The use of PAVA doesn't have to be purely defensive. It can be used offensively or in a defensive way that is proactive as well. That doesn't mean she can chase somebody down the street with it, and she didn't really. She used the spray in a way that there was a hybrid of the two. Her actions had an objective, and she helped her team achieve the objective, and I believe I've shown that the reason this lady officer used the PAVA spray was perfectly legitimate. But the scope of its tactical deployment in the incident is open to question because of the manner in which she used it. She used the spray as a crowd dispersal agent for which it's not really intended, and in consequence her actions were not in accordance with policy or authorised professional practice. Specifically, she adopted an uncontrolled posture using one arm extended towards a target. She pursued people rather than holding her ground. She didn't shout adequate warnings, at least not for everyone. She deployed the spray indiscriminately rather than targeting the eyes of a specific assailant. She sprayed an innocent person who may have been a child. She discharged the spray at quite close range, and I think those points and others could lead her into trouble on the disciplinary front. Of all those, I think spraying an innocent person is the most serious, though really that's an outcome of the others. I think the mistake this officer made was a very human one and can be described in ordinary language as getting a bit carried away. It can be explained in more sophisticated language using the concept of Batari's box. Batari's box describes how people can get locked into a vicious or virtuous circle of communication based on how their attitudes and behaviour respond to each other. The officer's communication with the crowd completely broke down, and she interpreted the actions of at least one or two people in the vicinity as hostile or non-cooperative because others had, in her perception, been hostile and non-cooperative. She failed to stop and reassess the situation. In summary, I'm siding with the officer overall, albeit with some points of criticism of her actions. I think the points in her favour are very strong. There was a violent melee and altercation with individuals impeding and obstructing the police. Class A and B drugs, a knife and offensive weapons were allegedly found. This allegation is still sub judice and not yet legally proven, but even if not true, this officer was not to know that and was entitled to act on the information and briefing received. Her actions succeeded in the objective of quickly clearing the immediate vicinity. Her actions were not inconsistent with the national decision model. The national decision model is arguably unhelpful for heat-of-the-moment situations such as this, and I suspect has been designed with the civil litigation industry in mind, especially certain race agitators, rather than with the priority as operational effectiveness. The current array of practice documents, policies and guidelines must be confusing for frontline police officers. There is a need for greater clarity, and that cannot help in incidents such as this. Police discretion applies. She is entitled to make these decisions in the heat of the moment. She is a lady officer and physically slight, therefore naturally more inclined to resort to a weapon than a physically imposing male officer who would typically be more measured and calm. In my opinion, British police forces should not in general be recruiting women and weaker men for frontline duties. But that's not her fault. The police recruited her. Is it a good idea in general to have women as frontline police officers? I can't say that I think it is a good idea in general, but I don't make these decisions. I think incidents such as this highlight the importance of training for the police and for all police officers. One bit of information I found was a national police safety survey that was conducted by the College of Policing in 2020. The survey received more than 40,000 responses from officers and staff across policing, which I would have thought is somewhere approaching half of all police officers in this country, or certainly in England and Wales. The survey received more than 40,000 responses, as I say, and the officers were asked which tactics they use regularly that may have been taught during what is called personal safety training, or PST. A total of 91% of respondents said that they were most likely to use non-physical conflict management skills on a regular basis rather than physical skills. However, roughly a quarter said that not enough time was spent training essential communication, and only about half said that their training had taught them how to diffuse confrontation in line with the conflict management guidelines and its mantra of de-escalation, communication and negotiation. While much of the current personal safety training is focused on physical techniques for containing and managing aggressive individuals, the conflict management guidelines created by the College of Policing emphasise non-physical aspects of conflict management of the kind that it appears the overwhelming majority of police officers prefer. And the idea behind the conflict management guidelines, according to the College of Policing, is to turn the guidelines into a national curriculum, so to speak, on personal safety for police officers. That survey does suggest that training on peaceful means for incident de-escalation could be improved, but I still think that there may be a particular issue for female police officers. And this is something that is not politically correct to raise, but ought to be discussed. Relevant to this is a story from July 2023, earlier this year. A female trainee officer of Greater Manchester Police was sacked, I believe that month, following excessive and illegal use of CS spray while trying to break up a pub fight back in 2020. The trainee officer claimed she thought the man was going to attack her with the glass, but a police misconduct hearing decided that her accounts outside the pub, in custody and in a report were inconsistent, and that her actions breached professional standards of honesty and integrity at a gross misconduct level, and she was dismissed without notice. I don't wish to cast aspersions on the panel members at the hearing, especially the chair of the hearing, who I see is a very respectable solicitor, but my suspicion is that the trainee police officer in that case was a bit hard done by and may have been the victim of political correctness, as the man who was sprayed with a CS gas was black, and it was suggested that the trainee officer's actions were underpinned in some way by racial motivations. That being said, the misconduct panel found that the trainee officer's action in using CS spray in a confined space and without warning was excessive and not proportionate, legal or necessary, and in reaching that verdict the panel added that the trainee officer's version of the events inside and outside the pub to other officers were untrue, exaggerated and embellished. To quote the panel chair, Solicitor Warren Spencer, "She discharged her spray with no attempt at communication or instruction, and its use was not necessary, reasonable or proportionate. It was also discharged from less than the recommended 1 metre, and the situation did not necessitate it." Is it significant that this was also a lady officer? There will be cases involving male officers too, I'm sure. Indeed, I quickly found one during my research. But I wonder whether the deployment of women in frontline policing roles does increase the likelihood of officers resorting to force, both individually and perhaps also collectively, when male and female officers serve side by side. In the past, police constables were tall men of a confident disposition. Women had a role in the police, but they followed a different career track that better suited their attributes. The reason for this is that competence was the dominant ethos, and it was believed that society's institutions should function. We stopped that. We now have a force made up of a mixture of men and women carrying out frontline duties because equality rather than competence is a dominant ethos. What matters now is not effectiveness, but whether certain ideas are being adhered to. That comes at a price. Women police officers, and also men who, shall we say, are physically weedy and in some cases effeminate, are more likely to resort to armed force. In the past, male officers who were physically imposing and confident would not have needed to use a chemical irritant spray in the situation of the incident that we've seen. Here's a picture that I think sums up the police of today. For some people, it sums up today's police in Britain in a positive way. For others, including myself, it just invites absolute contempt and disdain. Can we really take this seriously? A police officer, I really wish we could go back to calling them constables. A police officer should be someone who you're slightly afraid of. That means it has to be a masculine man. I'm not afraid of any of the officers pictured in that photo, and I do wonder if, to inspire respect, they have to resort to means that should not be necessary, such as using PAVA spray. Police officers should be male, tall, masculine and physically confident, able to convey authority without being a bully, sort of like a school teacher who has this presence about him without being overbearing. The type of person who is calm and friendly, but you know not to mess with him. I'm just old enough to remember beat bobbies. I grew up in a village and we had our own local beat constable. I still remember his name. Everybody knew him. He was a friendly and approachable person that everybody knew, but at the same time you weren't going to mess with him. I can't take a woman entirely seriously as a police officer, I'm afraid. I wish I could say different, and I would be a better person, perhaps, if I thought differently. But I can't. I'm just being honest with you. I'm making a generalisation, of course. I'm sure there are some excellent women police officers, but in general I'm sceptical. I don't think it's a role for a woman. I also can't take seriously a male police officer who's effeminate or physically weedy. Being a policeman is about authority, and whether you want to acknowledge it or not, there is a physical aspect to authority. It's also about credibility. I can't take seriously a policeman who has tattoos up his arm unless he's been in the forces, in which case I suppose it's okay. I don't think any of this is old-fashioned. I think it's about effectiveness. What I'm arguing for is an effective police force. Specifically, that competence is put back as a priority, which does mean that you have to have a male-dominated police force. Police work has to be a patriarchy, and by definition it is, because it's the sharp end of force and authority. You can still have the odd lady on the front line in the police, who may sometimes be better at diffusing incidents, and you can have a lady high flyer in the police, who might even become chief constable of a force. But she should get there on merit. I think you all know what I'm driving at. As a society, we've adopted this idea of equality regardless of characteristics, but equality can't exist in reality. I know this is not a welcome message in some quarters. However, I've noticed that everybody is against this lady officer, so I've decided to stick up for her in this video. My points aren't entirely in her favour, and I think it quite likely she will face disciplinary proceedings. But I'm not going to say that what she did was all wrong. Far from it.